Professor Ryan Abbott is a special guest. He has prepared a fantastic presentation, and it's a topic that everybody should be very eager to listen to. He's, as I mentioned earlier, he's an associate professor of law at the Southwestern Law School, and he's a visiting assistant professor of medicine at UCLA. He has served as a consultant on health care financing and regulation, intellectual property, and public health and for international organizations, for academic institutions, and private enterprises, including the World Health Organization and the World Intellectual Property Organization. He has published widely on issues associated with healthcare law and intellectual property protection in legal, medical, and scientific peer-reviewed journals. So I'm not going to take much longer to introduce him, but also I wanted to announce that he will be with us for the third hour to have a special discussion with the residents. So, Dr. Abbott, thank you so much for being here.
Thank you very much. Good morning, everyone. Well, I'd like to start the presentation off with a 2-minute and 30-second video produced by Consumer Watchdog and featuring Bob Pack in favor of the Troy and Alana Patient Safety Act.
I learned the hard way about an almost unbelievable fact. The third leading cause of death, right behind heart disease and cancer, is medical mistakes. Doctors making mistakes, often due to negligence, kill about 1,000 Americans every day. That's like 2 fully loaded 747s crashing every day. But you know what? It's in our power to do something about it. Just over 10 years ago, a woman high on vodka and prescription painkillers ran over and killed my 2 young children, Troy and Alana. It turns out that woman was a doctor-shopping drug addict. She wasn't in any physical pain, but still she went from doctor to doctor to doctor and got them all to prescribe thousands of narcotic-like painkillers. And the Kaiser Permanente doctors responsible were never held accountable for their negligence. I felt like my wife and I were victimized twice. So what we're doing now is sponsoring a new ballot measure, which would save lives and hold doctors accountable. It's called the Troy and Alana Patient Safety Act. First, it would require doctors to submit to random drug and alcohol tests, just like pilots, police, and bus drivers do. Doctors have incredible power. They hold our lives in their hands. But just like the rest of us, some of them have substance abuse problems. I don't want anyone with a hangover operating on me. Let's test doctors just like we do pilots and police. The second thing the Patient Safety Act would do is crack down on prescription drug abuse. We want to put a stop to doctor shopping for painkillers by making it illegal for doctors to prescribe any addictive drug without first checking a statewide database. That database would tell doctors immediately if a patient is getting the same prescription from another doctor. I know this electronic database works because I helped create it. The third thing the Patient Safety Act will do is hold doctors accountable for negligence by adjusting the cap on medical negligence damages. The current cap, $250,000, was set more than 38 years ago, and it's never been adjusted for inflation. That's just not right. The price of everything has gone up, way up, quadrupled in the past 38 years, except the value of our children's lives. Please, help us save lives. It's easy. Just sign the petition for the Troy and Alana Pack Patient Safety Act. Thank you.
So that petition has since passed and will be appearing on the November 4th ballot as Prop 46. Quick show of hands, how many of you have heard of this? So it's a good time for a lecture on medical malpractice, and for those of you who wouldn't have heard about it here, you'll be hearing a lot about it in the coming months. But I'm getting ahead of myself, and I really should spend a little bit of time talking about torts. In law, a tort is a wrongful civil act as opposed to a criminal act, other than under contract, where one party is harmed by another and it gives way to a right to sue. So tort law defines what constitutes a legal injury and what kind of redress you can seek. It says to some plaintiffs, you've suffered a misfortune and you can make it someone else's fault. To other plaintiffs, it says, sorry, you're out of luck. So it covers emotional, economic, and reputational injuries and violations of privacy, property, and constitutional rights, things like auto accidents and product liability and patent infringement, and of course, medical negligence. Medical negligence is a particular type of tort that, generally speaking, requires negligence. And negligence is the failure to exercise reasonable care that an ordinarily prudent person would exercise in similar circumstances. To be sure, you need more than carelessness. In fact, you need 4 things to have a tort. The first is you have to establish that a duty exists between you and a patient. So if you're at Starbucks and someone collapses in front of you with a heart attack, not only do you have no legal obligation to help them, you don't even have to call 911. And that's how we do things in America. But the patients you should be rounding on today, you do have a duty to treat. So really, this is rarely, though sometimes, an issue in medical malpractice cases. Most cases focus on the second element of a tort, which is the element to breach. That is to say, did a provider fail to follow the standard of care? And in medical malpractice cases, the standard of care is almost always governed by custom, which means that as long as you're doing what your peers would do in similar circumstances, you don't face liability. That's the case even if what your peers are doing isn't evidence-based or even particularly beneficial. So if a patient is injured by a surgical complication, but it's a known complication of a procedure and the surgery was indicated, you face no malpractice liability. Generally, that's proven by expert testimony, or very rarely, if it's an obvious area you don't need an expert for. Retained surgical instruments, for example, are the type of case that you don't need an expert witness. The third element is causation. If you had a duty and you breached the duty, was your breach of duty the proximate cause of an injury the patient suffered? So if you negligently failed to diagnose cancer in someone, but there was no treatment that would have altered the disease course, there's no liability. And then finally, to have tort liability, you need damages. The rule is no harm, no foul. So if you give penicillin to someone who's allergic to it, but for whatever reason they don't have an anaphylactic reaction, no liability. So why do we have medical malpractice law, much to the chagrin of practicing physicians? Well, the primary aim of malpractice law is to provide compensation to injured patients, or at least to a subset of injured patients, those injured by provider negligence. But of course, it is also more broadly thought to be one of the forces incentivizing quality in healthcare. Not incentivizing outstanding care, but de-incentivizing substandard care. On the other hand, tort liability is an imperfect incentive, so it raises costs on healthcare providers and healthcare organizations. It may increase the use of defensive medicine, which lowers quality, and it may reduce physician supply. I'm sure you've heard at some point someone talking about a malpractice crisis. This is the best data we have recently. It's from the National Practitioner Data Bank. Since 1990, reporters have had to report any settlement amount to the Practitioner Data Bank. For those of you who are residents, when you get jobs as attendings, healthcare organizations will check this data bank to look at your record. Reporting is only required to the California State Board if settlement amounts are $30,000 or more. But the last year we have data for, there were 12,000 payouts for a total of $3.6 billion. And actually, since 2003, total payouts have gone down pretty much every year, a total of 40% of both payouts and amounts paid out. Not shown here, 5% of doctors are responsible for 50%, more than 50% of malpractice payouts. If you break this down by state, you should be able to see, if you're sitting closely or have very good vision, that 5 states represent about half of all payouts, and California is number 3 with 222 million paid out a year in malpractice claims. Of course, that shouldn't be entirely surprising, given that California is the most populous state in the nation with 40 million people. Texas comes in second with 26 million. And so if you do it on a per capita basis, California payouts are squarely in the middle. You heard the video claim that 440,000 people a year are killed by medical error. That isn't a widely accepted figure. It seems to be the highest number Consumer Watchdog could find in some kind of peer-reviewed publication. And in fact, it was just the high end of a range that paper gave. The IOM famously in 1999 reported, citing existing studies, that up to 98,000 people were dying annually due to hospital errors, which would make preventable medical errors the nation's 8th leading cause of death. The exact numbers are disputed. A number of organizations have weighed in. Subsequently, the IOM, Health and Human Services, Office of the Attorney General, Healthgrades, which is an organization that rates hospitals based on Medicare discharges, and they found relatively consistent numbers somewhere between those two. Whatever the actual number is, it's clear that preventable medical errors are a very significant source of morbidity and mortality. So that may be true, but is there a relationship with malpractice claims? Any number of studies have tried to look at this empirically. This was just one illustrative paper I pulled from New England Journal from 2006, and it did an analysis of 1,450 malpractice claims. 97 of those had a legitimate injury, and 63% of those had medical errors in them. Of those, 73% were compensated. By contrast, only 37% were found not to have a medical error in it, and only 28% of those were compensated. It also found that out of every dollar spent on compensation, 54 cents went to expenses, which are attorneys and experts and court costs. So the authors conclude two things. They conclude that claims of frivolous lawsuits are blown out of proportion, that really most claims are merited, and most of the claims that aren't merited aren't rewarded, but they do nevertheless generate significant costs in defending against them. And also, it's not a particularly effective system if your goal is to get money to injured patients. A lot of this is administrative loss, although perhaps better news if you were a group of lawyers. The cost of tort liability. Estimates are pretty consistent. It's around a couple percent. That's what the Congressional Budget Office estimated in 2009. We spend around $3 trillion a year on healthcare. As you saw, payouts were $3.6 billion, but total tort costs are closer to $30 billion, right? And a large part of that is insurance premiums. Of course, then you have the nebulous cost of defensive medicine, which several studies have attempted to look at empirically. Michelle Mello published a good piece in Health Affairs a few years ago, estimating it at about $45 billion a year. So largely estimates have been around double the cost of direct costs in terms of defensive medicine. So a significant cost. All right, let's go back even further to 1975. Wheel of Fortune premiered, Margaret Thatcher defeats Edward Heath for leadership of the British Conservative Party, and Microsoft was founded. It's also the year that I graduated from medical school. In California, we had a medical malpractice insurance crisis, or at least the perception of one. Two of the largest medical malpractice insurers, Argonauts and Travelers, announced that they were going to increase rates by 400% and 300% respectively on physicians, and that they were planning to get out of the business altogether. It's unclear what prompted that, and there is some ongoing debate about it. But whatever happened, the message was clear. There's too many lawsuits, there's frivolous lawsuits, it's driving insurers out of business, and that's going to drive physicians out of business or out of the state. So physicians organized by the California Medical Association and the American Medical Association went on strike in May in San Francisco, a strike which spread to other areas of the state. And then and now, Governor Brown convened a special session of the legislature and proposed the main elements of MICRA. MICRA being something the American Medical Association says is the standard for tort reform. What are the elements of MICRA? So the most important element is that it caps non-economic damages. So generally speaking, there are two main types of damages in a malpractice lawsuit, non-economic and economic. Economic damages are things like medical bills and lost earnings, and non-economic damages are things like pain and suffering. So as a result of MICRA, non-economic damages are capped at $250,000. This has a pretty profound effect on bringing a medical malpractice suit, because if it means one of you, a newly minted vascular surgeon, is killed as a result of medical negligence, they get to sue for $250,000 plus what you would have been making every year for the next 30 years, which is a whole lot of money. On the other hand, if an undocumented worker dies or a homekeeper, they get to sue for $250,000. What does this do? It makes it a lot less lucrative to bring a medical malpractice lawsuit, and it reduces the arbitrariness and variance of jury awards, which can often be difficult for insurers and self-insured organizations to cover. So economic damages are fairly precisely defined, but non-economic damages are necessarily subjective. What's the value of a human life? There's not a right answer to that. But when they passed MICRA, they settled on $250,000. California is not alone, though it was the first to pass an act like this. 26 states, so the majority of states now cap non-economic damages, though few of them are at $250,000. And this is one of the provisions of tort reform that has been most strongly studied. And there is a relatively robust evidence base suggesting that it has a modest effect on constraining premiums. Premiums rise at a lower rate after laws like this pass, generally 6 to 13%. What else does MICRA do? MICRA caps attorney's fees. So these are not capped in other types of personal injury cases like slip or fall cases or motor vehicle accidents. With med-mal cases, an attorney can only get the first 40% or can only get 40% of the first $50,000, and anything after $600,000, they only get 15% of, with a sliding scale in between. In other cases, it tends to be 40% or 33% across the board. So what this does is it makes it a lot less lucrative for an attorney who's in the personal injury business to want to take on a malpractice case. It also eliminates the common law rule of joint and several liability. So before this act and at common law, if 3 physicians were found liable for negligence, and maybe UCLA also, and one of the physicians was found to be just 1% at fault for a negligent injury, the plaintiff could go after that doctor for 100% of the money. And that doctor would then have to recover it from the other doctors or their insurance plan or their organization. Under MICRA, doctors and organizations are only limited to their amount of damages. So it eliminates some of the unfairness of deep pocket defendants. It also puts in place something called the collateral source rule. So traditionally, if someone was seriously injured and required $100,000 in medical bills, they got to submit that to the jury. That's important because the jury could give them the $100,000, though the health insurer could ask for it back from them, though they don't always. But also that money could be used to influence how much they get in punitive damages and pain and suffering. But under MICRA, if you didn't pay the medical bill yourself, you don't get to introduce it in court. It also puts in periodic payments. So for amounts more than $50,000 in future losses, insurers may or sometimes even have to disperse this over time. Traditionally, if you are owed $500,000 a year for the next 30 years, you get that all as a one-time payment. But under MICRA, they can structure it in an annuity, and if you die before you receive the money, the insurers get to keep it. Finally, and this is the other, probably second most significant element of MICRA, it limits the statute of limitations. So the statute of limitations is the amount of time which, after an injury, you get to bring a lawsuit. And all states have statute of limitations on medical malpractice issues, normally 2 to 3 years. MICRA makes it so that you have 1 year from the date of injury to bring a case, or at most, 1 year after you learn of the injury to bring the case, and 3 years at most from when the injury occurred. So if you bring the case a year and a month after you learned about the injury, you're out of luck, and if you don't find out you were injured until 4 years later, you can't bring a lawsuit.
Only for adults.
Only for adults. They have different limitations for children, and I'd have to check on California, but sometimes the statute of limitations starts from when they hit the age of majority.
Unlimited.
Unlimited.
With children. When it's discovered.
When it's discovered. Fair enough. So has MICRA been effective at its stated goal of reducing premiums? Well, premiums went up 450% from 1975 to 1988. And then from 1988 to 2001, they diverged from the national and went down 2%. So what happened in 1988 or around then? Well, 2 things happened. First, a series of cases were decided between 1983 and 1985 that upheld the constitutionality of MICRA. So before that, there was a lot of debate about whether this was a constitutional law. Courts in other states have sometimes struck these laws down and sometimes not, and on two basic grounds. One, the argument that it denies someone equal protection because it singles out people who were injured in medical malpractice cases, and the other argument is on due process grounds because it prevents someone from seeking redress in the courts. So, after the courts upheld MICRA, insurers could be more certain when they were negotiating with plaintiffs' attorneys that this law was going to be held in effect, and really there was no risk of being on the hook for more than $250,000 for non-economic damages. But also, Proposition 103 came into force in 1988, and Proposition 103 heavily regulated the insurance industry, and in particular the medical malpractice insurance industry. It rolled back premium rates for doctors by 20%, froze rates for a year, and required that any rate increase required the approval of the insurance commissioner, which was a newly appointed position. So for us, it's a little difficult in hindsight to look back and say which one of the two of these, or if a combination of the two, reduced premiums, but it is clear that premiums in California are less than the national average. Now, back to the Troy and Atlanta Patient Safety Act, which is now titled Drug and Alcohol Testing of Doctors, Medical Negligence Lawsuits Initiative Statute, which was language chosen by the Secretary of State to be neutral on the ballot proposition. It's Prop 46, and actually it's really kind of three propositions in one. Normally, you're only allowed to have one substantive reform in a ballot initiative, but in the name of patient safety, the Attorney General decided that they could get all three of these on. They had to submit 500,000 signatures to get it on the ballot, and they submitted 830,000. So what does it do? You heard about it, but it does three things. The first one is it adjusts the microcap for inflation. So $250,000 in 1975 is worth $58,000 today. What it does is it adjusts that for inflation, starting with cases in 2015. That cap will be $1.1 million, and thereafter, MICRA will permanently adjust for inflation. Interestingly, when MICRA was passed, the backers of the act offered to index it to inflation if the trial attorneys would sign on to it, and the trial attorneys objected to that, thinking that this would be less likely to pass if it wasn't indexed for inflation. They have been kicking themselves ever since. Second, the Pee in the Cup Act. So California would become the first state to require random drug testing of doctors. Hospitals, which is defined by the act as acute care settings and outpatient settings, would have to randomly drug test you. They would also mandatorily have to drug test you after a patient's unexpected death or serious injury. And they would have to test you within 24 hours of an adverse event occurring. If you do not show up within 12 hours for testing, it is grounds for your license to be suspended. It requires hospitals to report any verified positive drug test to the board. The board has to temporarily suspend your license, notify the Attorney General, and notify all facilities where you have privileges. The board will also notify patients if you were found to be impaired during an adverse event. It will create a presumption of negligence in medical malpractice cases if you test positive on a drug test, which means that you would then have to rebut that presumption with evidence, which is difficult to do. It would also require all of you to report to the board if you reasonably suspect one of your colleagues has committed any medical malpractice, or if any of you were under the influence of drugs or alcohol. And like other reporting requirements, as in for domestic violence or elder abuse, if you make the report in good faith, you face no liability. The board will have to issue rules if this passes within a year to take it into effect, and it's going to be funded by an annual fee on physicians, so yes, you get to pay for this also. This is Cures. Quick show of hands, how many of you are registered with Cures? Well, that can't be right. Really? None of you have a Cures account?
I started one, but it's...
Fair enough. And then actually, quite right. So about 12% of California providers have Cures accounts. Well, that's interesting. Geez. So it's run by the California Department of Justice, which has been monitoring diversion since 1939. And it just got this electronic online system on in 2009, 2010. So what it is, you log on. To be honest, I started my Cures account as a result of researching for this presentation. So, but I can go on, type in my login information, and search any patient's name, and it will tell me if they've ever received a controlled substance. Pharmacies or direct dispensers have to report the fulfillment of a Schedule II through Schedule IV substance on a weekly basis. Before 2009, they had this system, but it was mostly for looking at drug diversion. So a physician could make a written request to them and get a written report back, but that took an awfully long time. So this act will require all of you by 2016 to have an account with them. It will require all of you, before you prescribe a Schedule II or III substance, to check the Cures database and make sure that they don't have an existing prescription, or if they do, make sure there's a legitimate need for a new one. And failure to do that is grounds for discipline by the board, including suspension of your license. So what kind of financial impact is this going to have on the state? Well, California has an impartial legislative analyst that looks at all of these propositions and comes up with estimates. And they've estimated this is going to cost state and local governments tens to hundreds of millions of dollars. The reason being that state and local government pays for a lot of medical service. Medi-Cal, employee and retirement benefits, directly operating facilities. It's obviously going to increase the amount of damages in medical malpractice suits, but they found that there was an uncertain effect on how many claims are going to be brought. Attorneys are going to want to bring more claims, but they think doctors are going to be incentivized to commit less malpractice. It is going to increase malpractice costs by about 5 to 25%, increasing health spending by 0.1 to 0.5%, and it is going to modestly increase defensive medicine. In total, the cost of the state is going to be less than 1% of their general budget. They also found that there were uncertain but potentially substantial savings associated with the Cures and drug testing. Cures is going to result in fewer drugs being dispensed and less prescription drug abuse, though it will be a burden, obviously, on providers. And they do estimate that physician alcohol and drug testing is going to lead to fewer medical errors, though there is a cost to performing these tests and the cost to the board of administering it, which is going to be less than $1 million a year, and physicians are going to be paying for it. So where does this proposition come from, and who's funding it? After all, it's very expensive to bring a proposition like this. Someone has to go out and collect 500,000 signatures outside of Ralph's. And the cost of doing that for this particular proposition was $1.4 million. Well, Consumer Watchdog was the biggest backer. Consumer Watchdog's a nonprofit founded by an attorney, and they largely do privacy and insurance work. And then, as you might suspect, trial attorneys are supporting this largely. So far, supporters of the act have raised $5 million to see it succeed. A lot more people oppose it. The California Medical Association, the California Hospital Association, frankly, any state medical association you could think of, various labor unions and business groups and cities, 585 organizations. And they've raised $56 million to defeat this act. So what do proponents of the act argue that it's going to do? Well, they argue that medical negligence is the third leading cause of death, which we talked about. They argue that 1 in 5 providers suffer from drug or alcohol abuse at some time in their career. They argue that many other safety workers have to get drug tested. They argue that doctors are the leading suppliers for prescription drug abusers. And they argue that this cap hasn't been adjusted in 30 years. And ultimately, they say that $250,000 isn't a fair value for a human life. Looking at some of these arguments, they aren't very good with statistics, but they got the 1 in 5 doctors argument from an article the board put out, which said that many people believe that as much as 15% of the general population has substance problems, and some experts think that maybe 1 in 5 doctors have a substance abuse problem, but they don't have any empirical evidence to back this up. The last year that data is available, there's about 130,000 licensed physicians with the state of California, and they took action against 46 of them for substance abuse problems. That's about 0.003%. So either there's not a lot of substance abuse out there, or the board isn't cracking down on it a lot. The Cures database. So the Watchdogs ads base the ads they're doing on a 2010 Substance Abuse and Mental Health Services Administration survey that found that 16 million Americans over the age of 12 said within the past year they'd used a controlled substance for a non-medical purpose. Though 55% of them they said they got it for free from one of their friends or relatives, and only 17% reported getting the drug from their doctor. So people who do get these drugs largely get them indirectly for doctors. Another problem with cures is that it is profoundly underfunded. It was built with a small federal grant. It's not robust enough to accommodate its current volume. And in fact, the California State Assembly accidentally stripped cures of all of its funding in 2011 because they eliminated the Bureau of Narcotics Enforcement and didn't seem to be aware that the Bureau of Narcotics Enforcement housed cures. You mentioned your application was pending. I called Cures about 30 times to try and get my application in, and finally got the one guy who works there, who's an employee in a different department, who's nearing retirement and thinks this is important to do, and he has a couple volunteers working for him. But he has a $0 budget, he has no staff, and there is zero IT support for it. Mike Small, by the way, if you want, he said you could email your application to him and he would expedite it. On the plus side, last year, Senate Bill 809 passed as a result of an LA Times expose on the cure system having no funding, and they did make some funding available for it. It gets a one-time $4 million grant. By summer next year, they're trying to rebuild Cures. They're trying to rebuild it so that it's all automated and paperless. Right now, you have to print out an egregious amount of stuff and get it notarized. And they're also trying to make it interoperable with electronic medical systems so that when you do e-prescribing or you're looking at your electronic medical record, it should say if someone's getting prescriptions and if they're getting out-of-state prescriptions right at the point of care. Of course, we know how interoperable electronic health systems are, so surely that won't be problematic. Incidentally, this is going to increase, if the act passes, the number of physicians using it from 10% to theoretically 100%, and Prop 46 doesn't make any additional funding available for it, so no one's quite sure what's going to happen with that. What's the argument against it? Well, it's going to raise costs on consumers. It's not exactly clear how much. The former legislative analyst who's working for physicians groups argues that it's going to increase health insurance costs by $10 billion a year, and that really this is going to trickle down from insurance companies to doctors and then to patients. And it's going to raise the cost of medical care, and in underserved areas, it's going to drive doctors out of practice. They also argue that Cures isn't a particularly safe system, though according to the people at Cures it is, and that this is threatening your personal privacy. And they note that the attorneys have attempted on multiple occasions to get this cap lifted in the legislature. Now they're bringing it to voters, and they're associating it with, they think, red herrings. They also note the cap hasn't been adjusted since '75. So where are we right now with this? The latest independent credible poll shows that most people support this proposition. 58% are in favor of it, and 30% are opposing it. Although we have a good deal of time between now and November, so you can expect some fierce advertising and campaigning on the subject. Quick show of hands here. How many of you are planning to vote against this act? Any for? All right. Well, if they're just having doctors vote, then you guys are in good shape. If you want my 2 cents on it, though I have no vested interest in it and am an academic and don't do medical malpractice law, I think it's got a lot of problems, obviously. The first one is Cures. Cures isn't set up to deal with this sort of thing, and it's uncertain that this is really that big of a problem. Sure, prescription drug overuse is a big problem, but it's not clear that doctor shopping is the real reason for that. It may more likely be overprescribing, someone giving someone 30 Vicodin for a tooth pull when they really need 3. So tort liability may just be a better way of dealing with this, saying that, well, if you were negligent in not checking Cures with this patient, someone can go to the courts with it. But board discipline is a rather large stick. Drug testing also is going to be very problematic. It's not clear to me that there's empirical evidence that this is really a large enough problem to have have this kind of response to it. It's going to be very difficult to administer, it's going to be expensive, and it's going to be very burdensome on physicians. As to the cap, which the opponents of the act say is really the driving force by this, I tend to think the cap adjustment is probably a good idea. It hasn't been adjusted since 1975, and there's no right answer to how much is someone's pain and suffering worth, but $250,000 really isn't that much money. I tend to think that regardless of which way that goes, that's going to have very little impact on all of you. It's not going to be a game changer. Some attorneys are going to want to bring more of these suits, but they still have the attorney's fees provisions in place. It's still capped at $1.1 million, and the effect on malpractice premiums are probably going to be a few percent. So while it's going to have an effect, it's not going to be a game changer. All right, and with that, I've tried to leave a bit of time for questions because I know this is a controversial topic that you no doubt have strong feelings about. All right. Let's go.
Great review. I just want to say that we'd still be fighting World War II if all the civilian leaders who led the Allies and all the pilots had to be drug tested before going on missions or making command decisions. Two, Winston Churchill most famously. Anyway, two, when Rahm Emanuel spoke here explaining the Affordable Care Act at UCLA, I think in late 2012, I asked him why was there no Med-Mal legislation as part of this, and he said we have no data to support taking action in that area, which is a bold-faced lie because of the California history. There's 30, 40 years of data from California.
Well, let me address both of those comments then. So Winston Churchill, obviously a great leader, but I suppose if you were to say to me, if I got to have one of you operate on me, would I choose one that was intoxicated or not? That's a pretty easy choice. That seems... but all right, so yes, that was a bold-faced lie. In fact, they did consider malpractice reform. They made a $50 million grant to consider it, and people were initially looking at some significant malpractice reform issues. The Congressional Budget Office has considered this on multiple occasions, and there's a fairly robust evidence base for most of these. Really, the only thing that's really proven to reduce premiums is the damage caps. All of the other stuff is kind of a conflicting evidence base and doesn't seem to do that much for it. And of course, there are all sorts of bold reforms for tort reform, like a panel of health experts for this sort of thing that we could talk about. Why did they not do that? Because it was a politically hot topic. Democrats are largely seen as aligned with trials attorneys, Republicans largely with the insurance industry, and frankly, the administration had enough controversial subjects in the Affordable Care Act. I think they just made the political decision that they didn't have the capital to deal with that then.
So much interesting psychology in this. A guy has a negative emotional event that happens to him. He takes dramatic action, ostensibly to correct the problem, and it has no relationship at all with the other. His kids were killed. He thinks he blames doctors. We have a drug addiction problem in this country. It's well known. Anybody who knows anything about addiction will that these people will lie, cheat, steal, manipulate their way past all of these regulations. So to blame doctors is a little bit. I think that I'm afraid that it will pass because it is anchored on this one. There are a bunch of red herrings, as you said, but it's anchored on this thing that doctors should be drug tested just like everybody else. Given that the average voter has the mentality of an 8th grader, that's what they're going to anchor on. And they're going to not be able to conceptualize any of it.
Well, hopefully when debate's going on, they won't be broadcasting this comment to voters, but I agree in principle that, right, of course, Consumer Watchdog is fast and loose with the figures they use. They aren't grounding this in empirical research, and they're appealing emotionally to voters. But that is how someone passes legislation, right? And that is why Democrats can't get anything useful passed. But yes, no, they have tied this in, and of course it's not entirely related with what happened to them. The doctors who prescribed these medications weren't themselves alleged to be intoxicated, so why they're now drug testing doctors doesn't have anything to do with his individual story. It's an emotional plea, but I think perhaps an effective one.
California is a large state and kind of seen as a leader in the United States for what trend happens here starts to populate to the rest of the United States. Is this still sort of specific to the proposition system that California has, or is this kind of process of circumventing legislation directly to the voters unique here to California?
It's somewhat unique to California. Of course, the issue of tort reform and these damage caps, whether they're constitutional, whether they should be lifted, what level they should be, I mean, that is ongoing all over the country. And California is without doubt an exemplar in this area, right? Everyone looks at California and says, look what they've done. What has this done? No, California is somewhat unique, I think, in its legislative process with bringing this to the voters. But, ultimately, if voters want something like this passed enough, they can elect a group of representatives who are willing to pass it, or, often appoint judicial representatives who are willing to support or oppose these.
Just as a point of information for the group, this issue is a really big one for the American College of Surgeons. They're very focused on this proposition. And there's a conference call in about 2 weeks' time to discuss and organize our chapters in the state of California to both all of the chapters, the Northern California chapter, Southern California, and San Diego chapter have signed on and publicly listed on the website as saying no. And John Ma, who's the immediate past president of the Northern California chapter, sends out every couple of days a little update what's happening. I guess a lot of this is sort of centering in Northern California, a lot of activity and those sort of things. Apparently, over the last couple of weeks, I guess these proposition groups, they have meetings with Democratic clubs, Republican clubs to try to get them to sign on or whatever. And this within the last week, they had a meeting, both groups, and yes, Prop 46 didn't show up. So all these Democratic clubs were there, and so the feeling is that, and many of them, the Democratic clubs are starting to sign on to the no piece of it. He talks a lot about this $5 million raise versus $50 million raise for advertising. And the last thing is apparently one of the attorneys who was part of the putting this together has, in the press, admitted that he thinks that this is not going to pass, and that if it does pass, it will be overturned because it's unconstitutional with regards to the
drug testing.
Yeah. So it'll be interesting to see what happens, but everybody in the room should know that the college is very interested in trying to organize.
Right. Obviously, whatever I think about this from a public health perspective and whether or not it's a good idea for consumers, clearly this isn't good legislation for physicians, right? And I think there's nothing wrong with advocating for an interest group you're in. So to the extent any of you are interested in getting engaged, there is going to be a lot of mobilization and a lot of movement going on over the next couple months. So for sure, just because right now the poll looks to be passing, a lot of things can happen between now and November.
Those who know me well know I tell stories that are too long, so I'll try to keep this short. This is only related to the topic, but I want to explain why I tried to sign on to the Cures website, because I think that the reason that I did so is of general interest to residents in the group. About in May this year, somebody stole some of my prescriptions, and they wrote for oxycodone 30s. They wrote for a total of 720 pills. They filled 160 pills to each of 5 individuals and forged my name. Signatures were all identical. When I found this out, I called the DEA that day. It took me 6 phone calls to get through to a human. And when the human spoke to me, she said that it wasn't really of any interest to the DEA that this had happened. She said that they only deal with conspiracies and with large amounts of drugs. So, naive individual that I am, I said, well, it's not 720 30-milligram oxycodones that I'm aware of, because it was at the pharmacy half a block from my office. Isn't that a lot of drugs? She said no. I said, well, is it not a conspiracy that somebody stole my and forged my name to 5 different individuals who were on camera as being seen picking up the drugs half a block from my office? She said, no. I said, well, then can I at least have your name so that I can prove that I did my due diligence in trying to alert the authorities that this has happened? And she said, No. And I said, why not? And she said, we don't give that information to the public. I'm the public whose prescription has been stolen, et cetera, et cetera, et cetera. So then she referred me to the Cure's website as the tonic for this problem, which proved irreparably difficult, at least for me. So I, to this day, have no notion whether these 5 prescriptions were the tip of the iceberg or the whole of the problem.
Well, though, that's a great story, and I think it's illustrative of 2 things. This is what happens when you have budget cuts, and even when you don't have budget cuts, there's no guarantee someone on the other end of the phone is going to be competent at all to do their job. So
my point is that A, there are new prescriptions, and B, there needs to be some improvement in the system to, even if there's one death due to somebody doing things of this sort, we need, a day of data out there. We need to know doing this. It needs to come to our attention, not through the coincidence that the pharmacist happened to know me, happened to call me because he knew he'd never seen me write for a 30 milligram oxycodone.
Right. Well, what you would need really is a lot more funding in a Bureau of Narcotics Enforcement, which they got rid of when they were short on money, right? But people don't want to pass propositions that raise taxes, and frankly, that's kind of the only way to do this. So in the meantime, what we have is a prescription drug crisis and not a lot being done about it.
Something has to happen, but
not necessarily
doctors over the head with anvils. Thank you.
We have no more questions. I would like to thank Professor Abbott one more time for a great presentation.